alternative paths not taken. We're more interested about what is right now. All right. Okay.
So Darren Andrews, 3917 Vicksbury Trail, Firemound. We're from McAdams. I just want to clarify, and I heard some questions in regards to the overflow here. We're not changing the drainage patterns. We're keeping the drainage patterns as is. That's not something that we'd be able to do without agreements in place, and that did not work out. So we are keeping that. There was a question about the weir being a little bit wider than what's existing, and we did that for the purpose because we are actually going in there because the water that drains to the west, we are actually reducing that amount for every storm event. We're reducing the amount of water in order to reduce the velocity. So the whole point is to actually make it better than what it is today. So that is why the weir is a little bit wider. We're decreasing by, I think, the 100-year storm, we're decreasing it from like 370 CFS to 330. So that's about a 10% reduction in stormwater, which is bringing the velocity down to non-erosive velocities. Now that's the whole point of this, is to make it better than what it was. So I have any other questions that you want to ask me that Chris hasn't already answered?
I mean, I have a question, and maybe that Matt can guide us on this, but the last two sessions that we had on this, it was implied we had an agreement. And everybody was hunky-dory.
Well,
And now there is no agreement. So is that anything that we need to be concerned about or should impact?
No, sir, I don't think that's something that needs to be within your purview. If your engineer is telling you that it meets the qualifications or the floodplain standards, then I think your engineer's discretion is what you should listen to. And it took me a bit to get caught up on what was going on here. I understand that there's been some couple of iterations with a berm, no berm. There may have been two different preliminary plats. I can say legally, there is a preliminary plat. If this final plat deviates from that preliminary plat, that's fine. Legally, that's okay. The preliminary plat is basically to say, this is how the land looks. This is what we approve today. If conditions change, the final plat can change, and deviate from the preliminary plat. So legally, I think you're fine there.
The other question that came up, not to drag up Muck, is the relationship between the agreement with Singh and the properties and maintenance over the long term. I know there was a lot of discussion at the council meeting about who's going to maintain this and what happens if it gets mucked up and it floods everybody and the homeowners don't have enough money to pay and all that stuff. Could you or Michael or somebody tell us kind of where did that end up, or does it need to be ended up? Another question.
Michael Canada, 1081 Post Oak Road, Copper Canyon. So ultimately, it's a business thing. It's in its inception right now, right? I mean, we don't have a permit. We don't have an approved plat. We're not starting. So right now, the business has the responsibility for that agreement. And
the business being the developer.
Yes, sir.
Right.
Yeah. Well, the property owner, then the developer will start, the developer will have it, and then ultimately that gets passed on to the HOA. Okay. And then it becomes the HOA's, because Paul's not going to do it. Neither is his development company. It's going to be the ultimately responsibility of the folks that live there and run the neighborhood, and it will have an HOA, as per y'all's request.
Correct. Thank you. Any questions?
But all the terms, everybody signed off on it. So
That was signed off in the last council.
Yeah, we tried to get something up north. It was a 4 or 5 month deal. Couldn't get a signature, and it was a dead end. So there is a signed maintenance agreement that's agreeable with the town. Up here it hadn't been filed, but it'll get filed when the street is filed.
Great, thank you. Just want to be sure that agreement was still okay with everybody. All right, further questions for the developer or his attorney or the landowner? All right, then I would entertain a motion that we approve the Jernigan Estates final plat allowing for the development of 12 acres and allowing for the development of 6 single-family lots located at 545 Tourniquet Road, Copper Canyon, Texas, 75077, and I'm not aware of any contingencies on this. So I will accept a motion to approve that.
I'll make a motion to approve it.
Thank you. Second? A second with Jeff. Any discussion? No? Any objections?
I'm just glad we got this one over the
Yeah,
end zone,
probably not the
or
only
into
one.
the end zone.
Yeah. So all in favor, say aye.
Aye.
Aye. Unanimous approval. Thank you guys for patience and everything else. Looking forward to some wonderful homes on there. All right. Third item, as you note, has been withdrawn. No action to be taken. We have the option now to go into executive session if anyone here feels we need an executive session with our attorney. Is there any?
I don't have anything to discuss in executive session.
All right, then we will move on to the fun part that everyone has really been waiting for, the P&Z training session with our new temporary in training or in interim town council.
I didn't know this was also going to be a job interview.
That's right. Yeah,
We're very efficient here.
So Matt has a couple of handouts. He was going to do a PowerPoint, but just I let him know that we didn't have a big screen and all that. So he's got some handouts for us. The other thing I'd like to do is once he goes through those is to share. I got copies at your seat of the ordinance that was passed by council on August 12th as it relates to the subdivision chapter 10. So we're going to hit some high points in that as well. So, and that will end up our training session, but we'll turn it over to Matt and let him do his P&Z training module.
I'll get you. Give me
hold on one second. Mark, you don't need to hang around for
I
this.
got nothing.
This is going to be a whole bunch of legal mumbo jumbo, so you don't need to hang around for this. And the only people who
Thank
really
you.
want to stay for this would be potential council members, commission members. And we're probably about a half an hour of training class.
Are these the crib notes?
This is a crib note.
You can tell how I went to school.
So we are still live broadcast. So Matt, introduce yourself again to the camera.
I'm assuming you want me over here. I don't know. This feels more comfortable, but I can sit
It's
over
fine.
there, wherever you want.
I could see you better there, so there you go.
My name's Matt Butler. I work for a law firm of Boyle and Lowry. I've been licensed since 2011, and I'm the only member in this role. Boyle and Lowry is pretty much the only law firm that I work for. I did work for Grand Prairie for a little bit for 12 years, and went back to Boyle and Lowry.
What's the nature of their practice by and large? Corporate, municipal?
All
All municipal.
municipal. So I started by Stan Lowry and John Boyle 40 plus years ago. Stan Lowry, it would be your city attorney. We're lucky enough to get selected to be your city attorney. I work closely with Stan. I have, since 2011. So that's a little bit about our background. And for tonight, I don't anticipate, I really want to keep this around 45 minutes. Maybe less.
That's great, because Kim probably hasn't eaten.
This is
Thanks,
very, very
Mitch.
high level. I'm not going to get into minutia. We can spend a whole lot of time talking about specific details and statutes, but it's going to be really high level. Hopefully, we'll be informed for you at the very least. Maybe pop in some questions that you want to ask.
So just kind of to throw you off your pace here a little bit before we start.
Please.
There's the biggest question that I think a lot of us have had is how much trouble am I in?
Yeah.
Or what do I got to do to stay out of trouble? Forgetting all the specifics.
Yeah.
The real issue here is, how much personal insurance do I need? That kind of stuff. So if you could kind of start with a high level, what are the risks of this? Now, don't forget the town council, they got their own problems.
Yeah.
This is just us.
So that's a good point. So the town council is different. So for y'all, as the advisory committee, your risks are really, really limited. And then even for the city council, they have what's known as legislative privilege. Like they adopt
a statute.
Or an ordinance. They have legislative privilege. They shouldn't have to worry about, being sued for laws that they pass. So they, as long as they don't step outside their bounds or pass laws for invalid reason, like race or just simply because they don't like someone. But so generally, they have legislative immunity. You guys also have legislative immunity, but on top of that, you're an advisory board. So let's say I recommend for approval this zoning ordinance. That's going to be covered under legislative immunity, no matter what happens up at the city council. So if someone sues the city council, and I'll tell you from my experience, I've never seen a P&Z member ever included in a zoning ordinance or lawsuit. It's usually the city, sometimes the mayor, sometimes the city council persons. I've never seen it be a planning and zoning member.
All right, secondary follow-up question on
Okay.
that, now that Mr. Bowers is gone. He brought up the new state law, new as in like last year, that basically changed the rules under which planning and zoning commissions can review the stuff we looked at tonight, according to him. And I guess I would like a definitive statement on kind of what things are in our purview and what things are not in our purview based on the change in the law. Because we did things a certain way for a long time.
Okay.
Based on our ordinances. And then that new law came out. And at the moment, we're still working on adjusting those ordinances unless this did it.
Yes, that's a large piece of it right there. So Matt, what he's referring to in September 23, September 1st, as you know, new state legislation kicked in.
Mhm.
And one thing that we were not informed of is that you couldn't submit or be required to have the developer submit a development plan and a concept plan. That was kind of wiped out. So it just narrowed it down to the preliminary plat and final plat.
Mhm.
Well, when we started our process in January, we were requiring them to do the concept plan and the development plan. And so that kind of got muddied the waters a little bit. And so to Mark, to your point, now that what you have in front of you and what was approved, a lot of those requirements and processes were in our subdivision chapter 10 ordinance. So all of that, as we'll go over later, has been taken out as it relates to development plans and concept plans and those type of things. And so it also talks about the 30-day clock that once they submit their application, we have 30 days to get it. They get it in front of P&Z, and then it kind of talks about that whole process. So a lot of that, as it relates to development, has been corrected in this ordinance. And there's a few other tweaks we'll talk about tonight as well.
All right, good. So we'll get to it.
Right. So as far as what changed back in December, it wasn't a whole lot. It was changing of like just some words and definitions. There was a lot of confusion before they changed that law, whether plats also included development plans and concept plans and all that. So it was an attempt to clarify it. And I guess at the same time, what they did was say that you can't make these development plans and concept plans as part of the plat package. That was simply all that it was. And what that does is that's going to affect your shot clock. And so, right. And so, if you're including all of these different plans at the same time that you're including the plat, you're really kind of condensing the time that you have to be able to review the plat. So really practically, it makes more sense to do the plat first because you need the 30 days, the full 30 days most likely to review the plat. And you probably know this, maybe you don't, but the shot clock being 30 days, once the plat application is submitted, considered to be completely submitted. If you don't take action on it within 30 days, then it's presumed to be valid. And that's at the P&Z level. So if P&Z takes no action, then it would be presumed to be a recommendation of approval. 30 days after that, if council doesn't take any action, then that's deemed to be considered an approved plat. And then you just got an approved plat and you didn't do anything. So that's pretty much what the state law on plats are. And that started to change, not the last legislative session, but 2 sessions ago. I don't know.
Well, maybe we're all creatures, and we got really used to concept plans and development plans as being useful tools
Right.
to help the developer make sure that when they come in with a preliminary plat, that it's
Right.
not going to be booted.
Right.
Because we've got 30 days, and if I'm under pressure, I'm like, well, let's just make it wait, come back next month because these
Right.
things are all wrong.
Right.
So the intention of those, from our perspective, was to accelerate the approval of preliminary plats by having gotten rid of a lot of the fluff before they ever spent all the money to present one of these gigantic
So,
things.
so as Troy said, the subdivision ordinance is what was amended and approved in the last council meeting. We'll go over that. And then there's a second document. It's Exhibit 10 or 14. It's a zoning ordinance.
It's a zoning ordinance,
And
yeah.
it also references things like concept plans and all of that. So that document is in the process of being edited, and I believe it's with the legal team now. So we should see that in the near future. But part of what the intent, the subcommittee that's been working on ordinances, part of the intent was to still preserve the development review committee and have an artifact, which is the preliminary plat, for developers to bring in so that we kind of sort through all those things. So it's not just whack-a-mole where you bring in a final and that nobody sees it until you bring in a final and then you reject it and you're back and forth on a final. So we still want to preserve because we think the development review is beneficial for everybody. It was just the development review had a specific document that's no longer valid, so we'll clean all of that up.
He's on the committee, as you.
That's great. No, yeah, no, that's great information.
Right.
All right.
Good. All right. Well, thank you. Do anybody else have
Well,
a?
so if, one does hit the fan, what is the coverage? through the-
Oh, yeah,
And is
yeah,
there
Troy,
Like a D&O coverage like I had in corporate world when I was on the board.
yeah, so when you're sued in your official capacity, the town's going to take that on, whether it be through the town attorney or through another law firm that gets hired. But, when you're sued in your official capacity, the town's going to take it on. But if you take a bribe, right? If you take money for doing so, that's different. Yeah.
So does the town have like liability coverage to a dollar amount that if a suit exceeded it?
I'm going to punt that to Troy. Are we in the TML coverage?
Yes.
Okay. Yeah. So basically, whenever we get a claim, first thing we do is send it to the TML risk pool, and they're going to decide whether there's coverage or not coverage. And I don't know what our coverage limits are, but that's the first step that we do. TML. Sorry, Texas Municipal League.
Yep.
And honestly, I haven't worked for a city that is not part of the TML risk pool.
Right.
I think nearly all of them are.
Yeah, Mitch, I'd have to go back and look at what that exact coverage is. Because we have our auto insurance through them, our building insurance and everything in between. So it's a risk pool. And so I'd have to go back and look at that specific number and see where it's maxed out or what the limitations are.
So hypothetically though, if you hit that limit in the suit, then what happens above that? Does it then fall back to individual?
No, it won't fall back to individual. It would then. So if we go above the limits, then at that point, it's going to have to come from public funds.
Self-funded. Okay. Thank you.
Come out of our budget, I guess.
Yeah.
Okay.
Or out above the budget.
Yeah.
Right. Okay. Well, sorry to get you off track. Did anybody
No,
else have
please
any
do.
other-
No, I this is boring stuff here. I'm fine. I'm fine with a little back and forth.
All right. So let's,
It's the concept plan and the development plan that are no longer.
over the
required.
preliminary stuff.
Yeah.
So now we're just kind of like, you get the DRC, from there you go to preliminary, and from there you go to final. But the change is partly in the timing. Once you get the preliminary in, which there's a definition of when is it in, you've got 30 days. We've got 30 days to work on it. And then after we're done with it, the council has 30 days to work on it.
Right.
Same thing goes for the final. So it gets rid of some of our kind of preliminary stuff and accelerates the time in which we've got to move on things.
Yeah, and it's really important to, like you said, define when it's considered to be submitted, like the plat, because that's when the clock starts to tick. So, whenever you have the full packet, that's the day, right? That's the day that.
So can you talk about that a second? Does that include our engineers reviewing it to say it is
No.
complete, or is it just
No.
the developer says, here it is, it's done?
You say, developer, these are all the items that we're going to need you to turn in and include with the packet. And unless it's included with that packet, it's not going to be considered submitted.
So Matt, let me just walk through that. So X developer comes in and says, here's my preliminary plat. It then would go to Chris. He would start reviewing it. There may be 10 things on there that were either A, missing or incorrect. So then Chris has about 5 days to submit that back to the developer. He then makes those corrections and then goes back to Chris. Chris then reviews it. And if it all comes back at 100%, then the 30-day clock starts, correct?
Yeah, that's my interpretation.
Okay.
Yeah.
And Troy, just for the benefit of everybody, so that, I believe that basically the flow chart for that timing and documents and all is one of the deliverables that Dunaway is working on for everybody.
Correct.
So
Yeah.
for those that weren't at the city council meeting, Dunaway was retained to help work through some of the, review the subdivision things, ultimately help with the engineering manual and the other ordinances. And so that's one of their first deliverables is basically a flow chart that should clarify that.
And Troy, if that's not perfectly defined when it's considered submitted in what we're reviewing now, I think we'll probably need to go over that and make sure that
Okay.
the language is right there.
If in the handout that I gave you guys, if you look on page 30, it kind of outlines that process. And Matt, the only thing that I have a question about, it says final plat to the town secretary for final action no later than 5 business days before the commissioners meeting or the P&Z meeting. And so if that developer submits that, like today, for example, we have a meeting today, Monday, and he submits all his stuff as a final version on a Thursday, then we technically can say, you've got to wait until the next month of the next P&Z meeting.
Yeah, I need to take a look at that. No, I want to say, turn in all your stuff, and then you've got 30 days, and we're going to take a look at it.
Okay.
That's my position.
Okay.
If you have to schedule a special meeting, you
Right.
schedule a special meeting. to
Right.
get it under
Yeah.
plan.
Okay.
Hey, Troy, about a week ago, I went into the website and actually tagged this ordinance
Mhm.
and printed it out. Is this any different?
No, this one is a little different because we had some minor changes that we're going to recommend to council to amend this
Just recently?
just recently, yes.
Okay.
And so I'll outline those on the pages that they're on. And so they're just little tweaks.
What you printed is what was approved in the last city council meeting then, and what we're looking at is one that will be submitted at the next city council meeting.
Yes.
Okay.
Yeah.
Just wanna make sure.
So this isn't the final, this isn't the current approved. This is a working update.
Correct.
But it is different than the last.
The only thing that's different is there's about 5 pages where we had crossed some things out that were missed, and we added a few things, and we'll run through those as well.
All right.
Yes, all right.
Ready to get,
Matt, you
ready to get rolling here?
Back to the original plan.
This is the original plan. Okay, so I'll run through this here, topics for this evening. I'll just real briefly, what your role is the Planning and Zoning Commission. Sunshine laws, and what I mean by that is the Open Meetings Act and the Public Information Act, and how that's going to apply to you. Conflicts and improper influence was where I planned to talk about your liability, but there's no slide on it. But those are just 2 things that I think you just need to be aware of, because those come with criminal penalties, and we just don't want you guys to be indicted. We'll do. I want, like I said before, I want you guys to be armed with all the information you need to be a good commissioner. So these first 2 slides are very, very basic. It's going to provide you where you get the authority for the Planning and Zoning Commission. So we're a general law municipality, and you don't need to know what that means. Home rule municipalities are required to appoint a Planning and Zoning Commission. Copper Canyon is a general law municipality, has the option to, and which it has. So the city council has adopted ordinances to create a Planning and Zoning Commission, which you'll see below, and that's in section 1.04 in that list. Basically, that's the section that has created this body, and it provides its composition and its terms. It even tells you when your meetings are, which I've never, which is pretty new to me. I've seen, I've seen some, you need to strive, it's up to the chairman, or, you need to have 1 meeting a month, but this one is very specific.
Yeah.
Yeah.
Actually, we have a question on that, Sheila. What did we land on? Where are we with that? Is it the 4th or?
Yeah, we're gonna, everyone said that they can meet the 3rd.
Oh, it is the 3rd.
So
Okay.
that,
All right.
so because it's in our ordinances, council will have to
Make a
adopt.
change.
Okay.
And that'll happen in,
Yeah.
on 9.
Does it have to say on the 3rd, or could it be general enough to say on the 3rd or 4th? I mean, why would we tie ourselves up forever and have to go back to council if we need to move back to the 4th?
It sounds like we wouldn't have to have it in there.
You could leave it very basic. Like I said, I've seen some that says at the commissioner's calling.
Yeah, I would suggest we do that, because if this 30-day thing happens, we may have to call quicker.
yeah.
Emergency meeting, yeah.
Emergency meetings
Yeah.
or special meetings.
Yeah. And there may be times where you need to have, 2 meetings a month.
Yeah, so I think we ought to leave it at commissioners or councils or somebody's not fixed like this.
Yeah, I haven't seen that before.
It's Sheila's discretion.
At Sheila's
At Sheila.
discretion. I mean, at 6 PM, what if it's,
Yeah.
Sheila.
I even asked Troy, I was like, can we do 6:30? Well, apparently not. And then lastly, this is very basic. Your duties are pretty much everything that's in chapter 211 of the local government code. And, I just gave you, just for reference sake, what these chapters are. 211 is zoning, 212 is plating. I don't know, has this body had much experience in reviewing and recommending adoptions to a comprehensive plan?
the town master plan?
Yeah, the master
Some
plan.
little stuff.
Not that much.
Yeah. So that's also part of the duties of the Planning and Zoning Commission.
I mean, I think it did come to us years ago. when
Yeah, it won't come very often.
Yeah.
That's why I asked the question. Yeah, it really won't come very often. And so again, it's part of your duties. It'll be presented to you, the comprehensive plan. You make recommendations just like you would on a zoning ordinance, and city council would.
Fortunately, we got a small town, so it's not that many master plan changes.
Yeah. So then it'll
It's
go
not
to
like
city-
we're adding territory or anything.
No, yeah. As Troy showed me the map, y'all are pretty much landlocked right here. Yeah. So your role in zoning, as I mentioned before, you're an advisory body. And so really, honestly, like a proper motion would be, I move that we recommend approval to the city council of this zoning ordinance. Because you're not actually passing the zoning ordinance. You're just advising approval to the city council. And if you have concerns, during a presentation of a zoning ordinance, those are the times that, you can tell them to staff, and staff can report that to council. Say, for example, P&Z, adopted this, 4-1, but here were their concerns, and they'll list out the concerns. So not only is it just a recommend approval, recommend denial, it can also include some other descriptions on what you would like to see as a planning and zoning commission.
It was one of the kind of, I guess, points of friction between us and council has been our role in contracts related to the properties.
Mhm.
We kind of saw our role as being, look, we're doing plats here.
Yeah.
We're not dealing with contracts. That's
Right.
kind of above our level.
Right.
And I think some of the council felt like we were shirking our duties by not, being specific about contracts related to the property. This last one specifically because of the drainage and all that other stuff.
Mhm.
And it's an odd one, as we all know, because you got the drainage is actually onto another person's property.
Mhm.
And I don't mean the person north, I mean Paul Singh.
Right.
So what is our role in determining the appropriateness and validity of various contracts related to certain affirmations that the developer is making
So
versus the council?
right. I'll start with this. If it's a contract between, the applicant and another third party that we don't really have any control over, whether they sign or don't sign, legally, that's going to be impossible to enforce. That's not something that I would recommend that you make a condition of a plat, because you're not going to be able to enforce it. If it's a contract between, like the second one we did, I think it would be a contract between the town and the applicant,
Maintenance agreement.
that makes more sense because, then we can, the town still has the ability to enter into the contract and still have some negotiations. But when we're talking, when we're conditioning approval based on a contract between an applicant and another party who we can't control, that's something that I would warn against.
So I'm not sure exactly how that would work in our last situation.
So I think,
That's why I
if I
asked.
can, I think what I'm hearing is if there's, from a P&Z specific standpoint, if there are concerns raised by adjacent landowners, it's appropriate for us to understand what those concerns are and to make sure, to the extent that it makes sense, those are addressed in the design.
Mhm.
But as far as an agreement between the landowners, that's above and beyond us. So somebody says, this is going to cause drainage issues onto my property. It's our responsibility and Chris's to make sure that it's mitigated, that it's not going to make things worse than they are currently pre-development.
Absolutely right.
Right? So that's where our role is, but an agreement between the landowners doesn't apply. But the city is now requiring maintenance agreements on detention and retention ponds, just so there's clarity of who's going to maintain those. And that is, and I think it's something that I don't think has been on our checklist, but I think it should be on our checklist because every development, given our drainage issues in town, basically has a detention or retention pond.
Mhm.
We just approved another one.
Right, so
contingent on
that's, I
maintenance
think,
agreement.
I think we should be, that should just be on the checklist. And then it sounds like it is a P&Z domain issue to say, is there an agreement? We don't have to review the agreement. We just need to make sure that there is an agreement before we can approve a final, as we've been doing, where we approve it subject to the final.
Yeah, and a maintenance agreement between the town
Right.
and the property owner.
And that maintenance agreement really is between the developer or the property owner and the council, the town,
Mhm.
but the council approves it, not P&Z, right? We don't
Right.
need to do anything about that agreement other than know there needs to be one and make sure that it's sort of on the radar.
Right.
And any recommendations we make are contingent on that ultimately being resolved.
Right, right. And another thing that you can do is, and you maybe already do it, is on the plat notes, say that the maintenance is the obligation of the property owner or the HOA, because the plat is going to be part of the record. So any person that buys that property is going to have notice that they're going to have to take.
And I think that was what drove the maintenance agreement on the Jernigan property, was the concern about, because it's, most of the developments, the detention or retention pond is within the development. This is the first one we've, I think, ever encountered where it was literally a separate piece of property, not
Mhm.
related to the development.
Yeah, and I don't necessarily think anything was done wrong in that case. It just looked like a situation where everybody was trying to do the best thing possible to develop that property, and it just didn't come to it. And the property owner has rights too, and if they're meeting all of our subdevelopment regulations, and it's a ministerial duty to approve, and we either approve it or we deny it and risk liability.
Well, and that's why I said I'm not clear how the definition you gave us applied to that property, in the sense that the developer was buying property from this property owner,
Mhm.
and they were going to develop this, but there was this other piece that the property owner was still retaining, and there was a contract between that citizen and this property as far as retention ponds. So it was between the applicant and a third party, although it was kind of a very intimately related third party,
Right,
because they wanted to sell their land.
right,
So that was between the applicant and a third party,
right,
because it was, as pointed out, that was a very rare situation
Yeah.
where you're counting on that third party to handle the drainage that normally would be handled by a maintenance agreement on the property itself.
right. And if you're conditioning your approval based on that agreement, and that third party doesn't want to sign, you're basically saying, to the applicant, you can't develop. Right. So that's kind of a barrier
And
and that creates a liability.
In this
issue.
case, the property owner was happy to sign that agreement. In fact, they'd have signed anything at this point just to get the deal done. So I'll take it on for perpetuity, and I'll drain it every year, and I'll make sure it's aerated and other such subjects. So it really wasn't a conflict. It was just the concern of the town that whether or not the agreement was strong enough
Mhm.
on that third party.
Mhm.
And, what would happen when he sells his house? Is the new buyer going to be aware of it? Are they going to live up to that agreement as much as he would?
Mhm.
That was really all the issues were surrounding at that point.
Right.
It wasn't really an objection from the third party. It was just, is that enough for us?
Yeah, I understand that. I think just the concern from a legal standpoint is that could create a barrier to them getting the approvals, the entitlements they need to build their property.
Understood. I mean, and it should.
Yeah.
But the question is that us or is that the council?
That's not,
Because like you just said, is that between the applicant and the third party?
Yeah.
And that's not us.
oh, so it's not you, and I don't think it's the council either.
Really? Okay. Don't say that in front of Mr. Bowers.
Okay.
Okay. Because the town felt very strongly about this. I mean, there were people up in arms about that particular aspect of the contract, and whether or not it would be upheld or would be enacted by the third party. Because, the developer could have just had a straw man sign it. And we're not supposed to check it kind of
Right.
thing. So in this case, it looks like it was a valid third party and with the resources to honor the contract. But again, there were a lot of people that felt that maybe he wouldn't. And if he didn't, what was the fallback?
Right.
And the fallback was a developer. And they're going, well, he's going to be gone.
Mhm.
It's going to be an HOA. And well, what stoutness does an HOA have if there's a massive problem? And the answer was, well, they've got insurance.
Right.
And they're wealthy homeowners. And if they don't take care of it, then we don't know what happens then.
Yeah.
Oh, never going to go there. But that was what the issue was.
Right. And a lot of what you're saying shows a lot of the risk of when the town tries to get involved in those third party, those neighbor issues. I think the better that we can stay out of that, or the more that we can stay out of that, the better. Just my
Well, yeah,
opinion.
no argument there.
Yeah, just, can I replay that from a different lens?
Sure. Yeah.
So it was implied by several individuals that this project was going to cause harm to these adjacent properties,
Mhm.
right? They're going to cause, this development was going to cause damage. So it was our job to protect our fellow citizens
Sure.
with these agreements that never transpired.
Not with the agreements, with the grading and everything else.
Engineering.
Yeah, the mechanics of the property.
Right.
Because again, our role is to make sure it doesn't make things worse. We can't expect them to make it better, although it'd be nice. And maybe they have in this case. But our goal is to protect those other people by making sure that things aren't worse. And from my perspective, what we were hearing from these other people is, I want it to be better. As long as this guy's doing everything, I would like, why didn't he fix all of our problems? It was kind of, they didn't say that, but that was kind of the sense to me. And so, we had an engineer, our town engineer says, hey, look, he's done what he's required to do, not make things worse.
Well, I know it's very emotional.
And it was emotional. We had an emotional from the adjacent landowners. So I'm sorry, I interrupted you. I apologize.
No. I just was trying to replay it from that.
Yeah. From a staff's point of view, from your engineer, attorney, your administration, our interest is, looking at the ordinances and seeing if they comply with the ordinances. And the intent of the ordinances is to protect, the property owners and if they comply with the ordinances, that's as far as it can go. If there's some additional concerns between neighbors, that's when I caution the city trying to get involved.
It doesn't help when one of the neighbors is a councilman.
So I have a question on that. I got the impression, and I'm very new to all of this, so I'll start with that.
But she's very inquisitive.
But
I like it.
I have lots of questions. I got the impression that while we're talking about the neighbor issue, that some neighbors just don't want development, period. And so is there a leg for them to stand on by saying you're kind of you're impacting my life, you're
Mhm.
impacting my, and a lot of people here have horses and cattle and, things like that. So it's not just, I don't want neighbors, but I have cows that roam or whatnot. So as this starts to come up, I think that would be really more the issue of, yeah, you got 30 acres, but I don't want 10 houses there. Like
Mhm.
we have cows now. And so now, so is there a way to stop development?
No.
Okay. Okay. That was, because people, yeah, well, no, but, yeah, but I think people are
Objection,
under the
move to strike.
impression that you can say, stop development just for, but I have property and I want to sell it.
Right.
So I have a right to sell my property. And then if it's zoned for 2 acres, and I can put a house every 2 acres if I want to. But then.
So long as it's within the ordinances. and
Right, so all of
access and
those
drainage
things,
and-
all of those things, but then how that impacts my neighborhood, that doesn't necessarily come into play here at all, or does it?
Well, I can answer that one because
Okay.
my wife used to live out in the country, had a lot of horses, and there's this lovely piece of property, a valley in front of her. She'd look out to see the valley. One day somebody bought it and put mobile homes all over it. And they're perfectly allowed to do that in her place. And her lesson from that is if you want to enjoy the view,
Buy it.
you own it.
Yes.
That's it. So the answer is no, we can't stop development,
Okay,
but we can enforce the rules that we've got.
okay,
And for your benefit, the reason we don't have much dealing with a master plan is because there's nothing in this
Yeah.
town that has any variance. I mean, everything's zoned 1 acre and almost all of that's gone. Those guys who were here just took the last piece that I know of that's 1 acre. Everything else is 2 acres, 5 acres, 10 acres, 100 acres. I mean, there's all of it, with the exception of our town center. That's the only area that's still kind of got some variability in it. And one of the challenges to the group that was doing let's change the master plan. Well, how do you downzone someone? She's got 2 acres. How do you go to her and say, from now on, it's going to be 1 acre? She'd probably like that, put more houses on it, but her neighbors wouldn't. And what if she's got 1 acre and we go, from now on, it's 2 acres? Well, you can't do that either. So you can't upzone people, you can't downzone people. So it's it is where it is if it's been zoned, right? I mean, the homeowners are going to give you a hard time one way or the other.
So legally, no. But if we just go and if the town goes and just rezones her property without her permission, then what you're looking at there is what's called an inverse takings claim, where my property's lost value, so I'm going to file a lawsuit against the town, and that's going to be generally what happens. So yeah, you can the town council, the town, they can rezone whatever they want, but not without the risk of liability.
Right. That's the presumption.
That's
I mean, you can do whatever you want so long as you don't care whether it's illegal or not, but
Right.
that's not where we are.
Yeah.
So I think so you'll see when you look at our master plan, we have one little area, I forget how many acres. Do you remember how many acres the town center is?
Commercial, I think it's 20, maybe 30.
Yeah, out of the whole town. That's it.
Yeah.
So anyway, that's why we have no experience and we don't expect to have any
Yeah.
experience. It's not going to be relevant to us.
So to answer your question, is there anything like neighboring property owners can do? So there's one mechanism under state law, and it's incorporated into the zoning ordinance, where if there's enough, I think it's 20% of property owners within 200 feet, if they object to it, then that particular zoning ordinance may only be passed at the town council by a 3/4 vote. We call it a supermajority. So if there's enough citizens to say, no, I don't want this, then yes, that is their recourse. But generally, towns and cities, they have full discretion to zone and rezone. And
can someone claim hardship if they have cattle and whatnot, and all of this is going to disrupt their livelihood? Because we heard that here, I think with this property that somebody was talking about that.
yeah, and so that could go into one of the reasons they protest. But then again, it goes into as a commission, if you don't like the development, you have the discretion. You have the full discretion to to say, no, I don't think this development is proper here, my recommendation is to deny it. And under zoning, you have the full discretion to deny. You can't do it, based on an arbitrary reason, like I'm going to flip a coin, heads, okay, yeah, I'll vote for it.
So my not liking it is not an arbitrary reason?
No. I mean, you can have different reasons for not liking it.
Don't I have to have a specific reason for not liking it? As in, it doesn't meet this ordinance or?
Not necessarily, and we can flip to the next page. I'll show you some of the things
Okay.
that are some of the good questions. And we can skip that
Nice
first.
segue. Thank you.
Yeah, we can skip that first box. That's straight out of chapter 211. It basically is the purpose of zoning. And that tells you everything, all the purposes of zoning. So if you look at that list 1 through 7, that tells you, what some of your best questions can revolve around. And I've included some topics that are great, great questions, great topics during your planning zoning commission meetings. What is the use that's going to be there? Is it suitable for that area and the adjacent uses around that area? What is it going to do to traffic, noise, light? Those are all great questions and topics that you can consider.
Okay, but so this is discussing the regulations
Right.
under which we work.
Mhm.
This doesn't tell us, this is talking about how the regulations are designed. But once the regulations are in place, aren't we supposed to abide by the regulations, even if they fail to do this? You follow what I'm saying? I mean, this says the regulations must be adopted and designed to. So this is specifically talking about
Yeah.
this about the people who write the regulations.
Right.
Kim and
Yeah. So this is a very generic. So this is, saying a zoning ordinance. This is the intent
yeah,
of a
this is
zoning
the
ordinance.
intent of it.
Right.
That doesn't really help us on the specifics of any particular project, in my view. I mean, the ordinance either does this or it doesn't.
Mhm.
And before it ever gets to us, there's an ordinance that we're supposed to read and abide by. So hopefully it does this, but if it doesn't, we can't go, oh, well, we're not going to approve this because
Well,
the ordinance left it out.
so this applies to the zoning ordinance, but also to zoning amendments. So every zoning change that comes before you, this applies.
Okay.
So this applies. So these are all the things that you're considering.
So I feel like there's a disconnect, and here's where I think the disconnect is. Think about it as two phases. At least this is what I'm sort of interpreting this. There's two phases. One is the phase where you set the ordinances or amendments to ordinances, and that's where this is a guide. But collectively, if I want to make some proposed changes to an ordinance, I'll draft them, and then P&Z as a group will look at those and sign off on them.
Right.
Right. Recommend them.
And they should be in accordance with this.
Right. But then phase 2 is, okay, now an actual hypothetical development comes in. And when we look at that development, we have to look at it against those ordinances as they exist. Meaning, I can't say, look, I really want a tree ordinance that requires every new development to have 10 trees that are 16 inches around. But the ordinance doesn't say that today. It only says it's 6 inches. So if a development comes in, I can't reject, this is kind of what I think you're trying to get to, Mark.
Exactly.
I can't say, look, I want 16-inch diameter trees, and you're not committing to that. Therefore, I'm going to reject it, right? Because the ordinance says 6 inches.
Mhm.
So we don't have discretion to rule in that second scenario where we're actually looking at a development for
Right.
something other than what is in the ordinances.
Okay.
That's where you're.
That's exactly.
Yeah.
Okay, so I see. So what I'm talking about is like the global level of zoning.
Yeah,
yeah.
And what you're referring to is when someone comes in
Day to
with,
day.
The
with
application of the zoning.
this is my
To the-
development plan and
Yeah.
this is where the ingress and egress is going to go
Yeah.
and all that. I was not prepared to go into that topic today, but I can't.
I just think the question is, when we look at a proposed development, we need to evaluate and sort of pass fail based on its conformance to the existing ordinances.
Absolutely.
That's what we
Right.
want
Absolutely.
them to be.
So
Yeah.
just to say, oh, I don't like it.
Yeah.
I'm not.
Yeah. So
I'm not
I
clear
get
how
what
that
you're saying.
helps.
So once you get down to the development plan and concept plan level, if you're just like, oh no, I don't like Wendy's. I'm
Yeah,
not
like
gonna
she
vote
says,
for
oh,
that.
I don't want any more development. No, we're not doing that.
Yeah.
No, you can't do that.
You will run in, yeah, you will run
Be in
into
trouble
Yeah.
if you do
So,
that, yes.
so if an attorney sits in front of you and says, why did you vote that way? We would fight real hard not to let that happen. But if it came down to it, what are you going to say? I just don't like it. That's,
Yeah, because I think
Because it's a.
Mitch's point is, I mean, because we really do have two jobs. One is the approving new ordinances, which
Right.
then that's important, but we don't do that often. In fact, we haven't done it in 10 years or whatever until this time. But basically what we do is day to day what you saw tonight, which is somebody comes in, they want to do something, does it meet our ordinances? That's basically what we do 98% of the time, I think.
But now we're working
Yeah,
on that.
We'll kind of go through this wave
address-
where we'll have a bunch and
Yeah.
then we'll have it again for another.
Decade.
Yeah.
But Matt, it's going through this process, and like to Mitch's point, if we said, Mr. Developer, we know our requirements, 6-inch caliber trees, would you consider doing half 10-inch trees?
oh yeah, that happens everywhere.
Yeah, and so then if you have a quality developer, they step up and they do that, or developer can very well say, nope, I'm
Yeah.
You
sticking to
can
what.
ask, but you can't require.
Right.
Right.
It's Mark's example. Every time a development comes in, it's boxes.
Yeah.
Yeah,
And Mark
Well, then-
begs and pleads to make it.
Yeah,
more
it-
interesting.
winding roads.
Winding roads.
Yeah. The applicants, they know, right? They know what they need. If you're asking for, I don't like this because of this, and this,
But that's why this new law
yeah.
really favors the developers so much. I mean, this is a developer law, let's face it. That's who pays all the election money. Because in the past, you said, well, let us think about it a while longer. Yeah, we'll put it off next month, maybe the month after. There was no pressure for us to move on a time schedule. So we could do that kind of, hey, I want some windy roads. Well, think about that and come back again. You can't do that anymore. Now you got 30 days, that's it.
But it does, but because
You can
of
still
that,
ask.
well, because of that, reviewing all the ordinances is all the more important, right?
Right.
Forethought around what are the things we want to require so that it becomes less of a negotiation. If you
Right,
want
it becomes
but
more,
this is what it
yeah,
is.
more detailed. Yep.
So what it sounds like is, as a group, you deal more often with plats and concept plans.
Oh, absolutely.
Than zoning
Yeah.
ordinances.
Yeah, and again, the whole point of the concept plan, the development plan was not to be a roadblock. It
Oh,
was
yeah.
trying to be helpful.
Mhm.
And, if they don't find it helpful, fine, bring us one of these big expensive packs of paper and we'll tell you what's wrong with it.
In fairness, thinking back to the last 4 or 5 years that I've been involved in this, we probably had an average of 3 to 6 ordinances a year, updates to ordinances, things like that. I'm thinking about when we talked about accessory buildings,
Right.
setbacks.
Oh, that was a long time ago.
But I'm doing, kind of on average, it's probably 3 to 6 a year.
Yeah, on average, but there was like you say, it's in bursts.
Yeah.
That was probably,
Yeah.
4 or 5 years ago, there was
Right.
like a bunch of them.
Right.
And then it's kind of not been much since then.
Okay, so I'm talking about zoning next. Sounds like maybe that's not what you really need to hear a lot about, but.
Let's go through it.
Well, it's important now because we are rewriting them. So
Okay, right. So you called it a master plan. Is that what it's called in Copper Canyon?
Master
Your-
plan.
Yeah, your comprehensive plan. And I'm assuming that it encompasses a future land use map.
Yes.
Yes.
Yeah.
So,
Troy, could you be sure and give them one or Sheila? They need that at their office on the wall.
certainly. One of the requirements for zoning ordinances, so someone comes in for a zoning amendment, I want, this 12 acres, to be zoned, whatever. And it doesn't comply with the comprehensive plan for whatever reason, probably the land use map. State law requires that zoning amendment comply with the comp plan, with your master plan. So what would have to happen is you would have to amend your future land use map. In that case, if the P&Z and the council are like, yeah, we love this development, we want to adopt this ordinance that doesn't comply with our comp plan, that's going to have to come with it an amendment to the comprehensive plan. Does that make sense?
No, so could you say that in different terms? So
Yeah, I'll
if-
say-
if I-
I'll say
if everything's zoned for 2 acres and somebody comes in and says, I want 1 acre lots, is that what you're talking about?
So Matt, let me throw this scenario out there. So town center, you have 3/4 acre lots, you have 1 acre lots, and then if we wanted to zone that straight commercial, because now we just want all 2 acres, then we would have to come in and rezone that town center use as straight commercial because we really don't want small lots in there, a
Okay.
mixed use type environment. So in order for us, if Joe developer came in and said, yep, I agree, I'm going to do 1 acre lots, I'm going to have some home-like commercial buildings out on 407, fantastic, I'd love to do it. We would have to we'd have to change that
Mhm.
before we could approve that.
So-
The comp plan, you'd have to change the comp plan.
Yeah,
Right,
and I can,
Master plan.
Okay.
maybe I can phrase it a little bit different. Let's say that there's one before you that does comply with the comp plan. Just because it complies with the comp plan does not mean that you have to approve it. Just because the future land use map says this is going to be town center, and it's a zoning amendment. Just because it complies with the comprehensive plan doesn't mean you have to approve it. The comprehensive plan is purely a guide for the city for its future uses.
So land use can change, but zoning can't.
Well, it always can, but
Well, without affecting the landowner. Because the landowner is gonna come after you if you downzone it.
oh, yeah, for sure. That's gonna happen.
But you can mess around with the land use if you state in your
Yeah, and I've got a real
master plan.
Yeah, I've got a real world scenario on that. One of the cities we worked for, they were looking at changing, they called it the future land use map, the FLUP. It's ridiculous. They called it the FLUP. There were a lot of citizens that were really, really upset that their properties, as indicated on the future land use map, were going to be rezoned. That's not actually that's not what the comprehensive plan does. It's just a future guide. So does that kind of help you?
In our case, we've already got the property zoned,
Yeah,
right? So that's kind of a non-issue for us. Everything is zoned,
right.
because we're small enough, everything's zoned. The only one that's a variable zoning is the town center. And I guess I didn't really agree with your example because it already it says you can do commercial, you can do 1/3, you can do a half, you can do anything.
It doesn't really have zoning, it has permitted uses.
Correct, right? So it's zoned town center
Right,
and that's it.
with a list of permitted
It has
uses.
a list of permitted
So
uses.
you, in theory,
So you
could
could do
change the
100% of
permitted.
this or 100% of that.
So in theory, you could change the permitted uses, that would be an amendment to.
That would be the
master
amendment.
plan.
That's right.
No, yeah,
Master plan.
sure, yeah.
So my question was though, we have things that are zoned for 10 acres, let's say,
Mhm.
and we do. Can the property owner come in and say, I want this rezoned for 1 acre? So now I have 10 1-acre lots that I can then sell instead of one 10-acre lot.
Mhm.
I think
So-
that would be the
Well,
road.
let me take it one step further.
They
Well,
can
let me
ask,
take-
but you don't have
Let me
to
take it one step
approve
further. So let's say Kim comes in and wants to do that. And let's say that her zoning does, I mean, we wouldn't, just for the record, because nobody wants smaller lots. But hypothetically, to your point about the master plan changes, if you change just one parcel, does the master plan need to be changed to reflect that downzone of one parcel?
Yes, because otherwise you run the risk of,
Yeah, so that's a
That-
good question. So like Boots Ranch that was rezoned to 1,
Mhm.
I suspect the master plan was never adjusted for that. I don't remember that ever being done.
if it's been 2 years, you're safe.
I'm just saying,
I don't
if the
know.
master plan
And
was
I
amended.
forget, was it? I didn't know it was down.
I don't know.
I guess I missed that somehow.
It was R1.
PD.
It was R1?
So-
But it was
so the-
R1 to
in-
begin with, wasn't it?
The,
It wasn't 2 down to 1?
the real world danger, if your zoning amendments or zoning changes don't apply with the comp plan, is it gives adjacent property owners ammo to challenge the ordinance. That's the real world effect of
So to
this.
her example, yes, someone can come in and ask, and we can say, no. And we don't need a reason except to say, master plan, zoning,
10 right.
Yeah,
no.
So
Now, on the
now,
other hand, I guess a more complicated thing would be what if, for the town's own reasons, kind of like Vickery, the town decided that, well, maybe 10 houses there would be really nice. Right now, it's this dead area where we're collecting no taxes because it's an ag exemption, but we put $10 million houses on there, more tax dollars. Maybe we want to do that. In theory, yes, you could ask, and yes, we could do that.
Correct.
But of course, we have some ticked off neighbors. But again, this goes to the whole point is that, like, if you want to save it, you better own it, right? So there's obviously reputational risk, but we could do that if the town decided it needed that development at that entrance to the town or something.
Mhm.
So yes, it could be done,
So,
but all of us would be, tarred and feathered. But
Right.
you could do it.
they don't know where I live. So then going, if Boots Ranch was downsized, right? And somebody comes in and they want to now downsize, can a lawyer come in and say, well, you did it over there, now you have to do it over
No.
here? So there's no precedent.
No,
set.
no,
So-
no, there's no
So it's
precedent.
what we did at Boots Ranch, makes no difference. And nobody could say you did it before, you have to do it now.
Well, and
I mean, I've seen them argue that, but no.
Okay.
there is no such thing as a precedent.
Correct.
Now,
Okay.
Now, the Boots Ranch was interesting because it was sold by the guy who owned all around it. So there really weren't much in the way of neighbors to complain about it.
Okay.
So in other words, like if you